Morning, Mr. Secretary, and welcome. It's my pleasure to once again welcome you to the Subcommittee on Labor, Health and Human Services and Education, and we're looking forward to your testimony very much. This hearing is to review the Department of Labor's fiscal 2019 budget request. The committee understands that much of the budget had already been written when Congress agreed to increase discretionary budget caps last month. We need to be cautious when considering this request to include both the budget and addendum in our review of the budget. The committee's task is to carefully consider the department's request and to make recommendations for the funding of needs of critical programs, including job training, worker safety, labor statistics, and others. Secretary, I want to thank you and commend the dedication and hard work of you and your staff. You've been immensely helpful to this committee, and without it, our work here would be much more difficult. I particularly want to thank you and your staff for welcoming us staff from this committee, and obviously my personal staff, myself as well. It was really helpful, honestly, to sit down and talk to your people. I called it the John Klein Alumni Committee over there, since so many of your key people work for my good friend and former chairman of Education and Labor. But you got a great team, and it was a delight to visit with them. There's several issues I look forward to asking about this morning. They include details on the department's apprenticeship initiatives, an update on the department's efforts and approaches in reducing the skills gap, the reasoning behind requested increases in funding for federal enforcement in the department's worker protection programs, how additional money in the recent budget agreement might impact your proposed cuts in various job training programs, and how the department intends to build upon the reemployment services and eligibility assessments initiative and reduce improper payments more broadly within the unemployment insurance system. It's unfortunate that we're considering fiscal year 2019 budget requests before the final consolidated appropriations bill for fiscal 2018 is enacted. Certainly no fault of yours, but we're running a little bit behind where we'd like to be. However, we hope to have something done on that soon and to move quickly after that into the fiscal 2019 appropriations process. I'm sure members of the subcommittee will have many questions about the budget and policy issues at the department. So without further delay, I'd like to remind our members and our witnesses that we will abide by the 5-minute rule so that everyone will have a chance to get their questions asked and answered. But before we begin, I'd like to yield 5 minutes to my great subcommittee ranking member, the gentlelady from Connecticut, for her opening statement.
Thank you very much, Mr. Chairman, and good morning to you, Mr. Secretary, and welcome to your second appropriations hearing before this committee. I think it's fitting that labor is the first hearing that we will hold for fiscal year 2019 because, and this is my view, for the past year under this administration, working families have been under an all-out assault, in my view, as I said. We have witnessed both the elimination of worker protections and the unraveling of a social safety net. Let me quote from one of my heroes and the longest-serving labor secretary in our nation's history, Frances Perkins. She said, and I quote, "The people are what matter to government, and a government should aim to give all the people under its jurisdiction the best possible life." That's how I view the mission of this department, and unfortunately, I think this budget request fails miserably in fulfilling that mission. It represents the hollowing out of the Department of Labor and a fundamental failure to govern. Mr. Secretary, the biggest economic challenge of our time is that people are in jobs, and too many people are in jobs that do not pay them enough money to live on. We need to enact policies that ensure that everyone can benefit from the economic recovery and that everyone has the training they need to get good jobs with fair wages. In your testimony, you talk about the Republican tax law, yet the tax law incentivizes outsourcing. It encourages companies to export jobs by creating a lower rate for multinational corporations to invest abroad, nowhere near the corporate tax rate for domestic investments. Right now, a company that makes their wares outside of the United States pays up to 13% in taxes, and yet the same company making their wares in the United States will pay 21% in taxes. And several of us, and I've recently introduced legislation striking the sections of the tax law that create this incentive to outsource. Furthermore, since the tax bill went into effect, the majority of corporate tax cuts have been used on stock buybacks, which benefit wealthy shareholders and company executives, and not our workers. The vast majority of benefits from stock buybacks go to the richest 10% of American households, according to the Joint Economic Committee. American companies have announced more than $178 billion in planned stock buybacks, compared to less than $6 billion in bonuses or wage increases. That means 97% of the tax law's benefits have accrued to wealthy shareholders and executives, while only 3% of the benefits have gone to workers. Even reported bonuses for workers have been misleading. I'll use Walmart as an example. Bonuses for their employees. Let's talk about the stringent requirements for being eligible. If you work for more than 20 years of service, you got $1,000. 15 to 19 years, $750. 10 to 14 years, $400. 5 to 9 years of service, $300. 2 to 4 years of service, $250. And less than 2 years of service, $200. I think $200, getting additional $200 is fine. It's good. I don't decry that. I think that's fine. I don't knock that. But spare me, my gosh, if you're going to tell somebody they're getting $1,000, why isn't everyone getting that $1,000, and why is it just once and not permanently? I might also add that Walmart shuttered their doors of 63 Sam's Clubs, cutting 10,000 jobs. I want to turn to the subject of today's hearing, and that's the department's budget request. Your request would decimate the employment and training system by cutting $1.1 billion, 12% of funding, and eliminating critical services for Americans who need help to find a job or to move to a better-paying career. In 2020, 2 out of 3 jobs will require training beyond the high school level. And it's up to us to meet this need. Yet, the budget cuts Job Corps by more than $400 million, shuttering Job Corps centers across the country. Your testimony says that the budget eliminates programs that are less effective. Yet, in fact, it zeroes out programs that are known to be very effective. For example, a 2017 Urban Institute report concluded that the benefits of the Senior Community Service Employment Program outweigh the small federal investment that we make. Migrant and seasonal farm worker job training places participants into employment 90% of the time and increases wages threefold. At the same time, the budget proposes to redirect funding from the successful evidence-based registered apprenticeship model, which I might add I've heard directly from employers is not onerous, to create a new untested scheme that is duplicative and confusing. And while the president claims he will be tough on trade, in his budget he proposes to eviscerate the office whose mission is to identify cheating on trade deals. He wants to cut the Bureau of International Labor Affairs, ILAB, by $68 million. That's the lead agency for investigating labor violations in trade agreements with our trading partners. It compiles the annual reports on products that are made with child labor or forced labor. In your budget request, you focus on modest increases to compliance assistance programs. And while I agree there needs to be a balance between compliance assistance and enforcement, I am concerned that you plan to scale back enforcement activities, which would result in less oversight of bad employers that deprive workers of honest wages or expose them to dangerous health and safety hazards. OSHA has only enough funding to inspect every workplace under its jurisdiction every 159 years. And yet the budget proposes to eliminate funding Susan Harwood training grants to protect and educate workers in the most dangerous jobs. You're going to cut funding for the Women's Bureau by $9 million. The agency continues to serve as a critical function to improving the work environment and opportunities for women. It is simply unacceptable to slash its budget at a time when women make 80 cents on the dollar on average compared to men. That's about almost $10,500 in lost wages on average every year. Given the Office of Management and Budget have effectively prohibited progress towards addressing the gender pay gap by disallowing the EEO-1 survey of pay data, it is all the more critical to adequately fund the Women's Bureau, its research on pay equity. Final note, the administration has proposed a paltry 6-week parental-only paid leave scheme in the budget, despite the fact that more than 75% of the people who take family or medical leave do so for reasons other than parental leave. The president's proposal does not reflect the reality that workers face. Taken as a whole, the President is proposing to cut the Department of Labor by $1.2 billion. That's a reduction of 10%, Mr. Secretary. We need to know today, do you agree that your department should be cut by $1.2 billion? I'm dismayed that the administration's decision to rob workers of fair pay by throwing the proposed overtime rule into limbo. I oppose your proposal to hurt tipped workers by allowing their employers to pocket their tips. This is, in essence, legal wage theft. It disproportionately affects women. According to the Economic Policy Institute, 80% of tips per year would be taken from women. And I oppose the department's push for association health plans, which will lead to higher premiums in the individual and small group markets, more Americans with junk health insurance, and more Americans without any health insurance at all. It's the obligation of this subcommittee to ensure that the working men and women of this country are not harmed by reckless cuts and a disregard for their well-being. Should this budget proposal be implemented, it's my view that the harm would be irreparable. Mr. Secretary, I look forward to hearing why exactly you think working people should bear the brunt of cuts, while millionaires, billionaires, and corporations reap the benefits of this administration's agenda. Thank you, and I look forward to the discussion. Thank you, Mr. Chairman.
Thank you. Mr. Secretary, I'm advised we're going to be joined at some point in the hearing by the full chairman of the full committee and the ranking member, and at that time I'm going to allow them not to interrupt your statement, but to offer any opening statements they care to make. But with that, since they're not here right now, if we can, we'll proceed with whatever opening statement you care to make to the committee.
Mr. Chairman, thank you, Ranking Member DeLauro, members of the subcommittee. First, let me say thank you for your invitation to testify. I'm pleased to appear to discuss the very important work of the Department of Labor and to discuss its proposed budget for fiscal year 2019. I'm honored to lead the department in its important work. At the beginning, let me just say that in the first year, the Trump administration has delivered strong opportunities for American workers, American job seekers, and American job creators. 2017 was a year of growth for the American workforce, for the American economy, and we can look at any variety of economic indicators. I'm not going to go through those right now, but those are the facts. 2017 was also a busy and productive year at the department, and I'd like to just present some facts. The Employee Benefit Securities Administration recovered nearly $700 million in enforcement actions. It obtained nearly 100 criminal indictments and recovered an additional $437 million on behalf of nearly 400,000 plan participants and beneficiaries. MSHA, the Mine Safety and Health Administration, fulfilled its statutory mandate to inspect all underground mines 4 times and all surface mines 2 times per year, and in addition, conducted non-mandatory inspections. In total, it conducted over 40,000 inspections. The Occupational Safety and Health Administration conducted more than 30,000 inspections. And I note that last year, 2017, marked the first time in 5 years that the inspections increased year over year, despite a suspension of enforcement in certain areas immediately following the hurricanes because of hurricane recovery efforts. The Office of Federal Contract Compliance Programs reached the largest pay discrimination settlement in more than a decade, where a company agreed to pay $5 million in back wages to settle allegations of discrimination against 300 women. The Office of Labor Management Standards investigated 121 union officer elections after complaints of violations and conducted 265 criminal investigations, recording 82 indictments. The Office of Workers' Compensation Programs implemented aggressive program integrity and pharmaceutical cost control measures that resulted in expenditures, in a reduction of expenditures of $221 million as compared to the prior year, largely attributed to decreases in opioid prescriptions. The Wage and Hour Division recovered more than $260 million in back wages for nearly 250,000 employees and conducted more than 29,000 investigations and cases. Looking forward to this year, our intention is to continue this enforcement effort, and I'd like to highlight 2 programs in particular that we're in the process of announcing. The first involves MSHA, and the point here is simple. Mine operators must pay their health and safety fines. Now, Americans across the country understand that if you have a fine, you have to pay it, and anyone that's received a ticket knows that quite well. Yet, if you look back over the last decade, $67 million in fines have accrued in MSHA that have gone uncollected, and that needs to stop. And so beginning immediately, we are notifying individuals that have not paid their fines, and they need to pay their fines. And we have legal methods at our disposal that we can implement if they have not paid those fines. $67 million in uncollected fines, if we want to talk about enforcement, over the last decade. Secondly, in the Wage and Hour Division, we're implementing a program called PAID, the Payroll Audit Independent Determination System. Right now, if a company is aware of a mistake, there is no simple mechanism for them to come forward and say, we made a mistake, we want to voluntarily come forward and pay our back wages. And so the Wage and Hour Division, through this program, will assess the amount of wages due and supervise payments to employees. Employees will receive 100% of back wages owed without costs of fees, without attorney's fees. This will happen much faster than through litigation. The program will include important safeguards. If a company is under investigation, it will not be eligible for this. This will be reserved for companies that realize their mistakes and that they come forward. And the intention is to get the money that is owed to hardworking men and women faster without attorney's fees, 100%. Finally, I want to highlight some regulatory efforts that I know you're all familiar with. The small business health plans or association health plans. There's a proposal, I believe today is the last day for public comment on the proposed rule. And it is so important that we look at this. 11 million Americans may be uninsured because they or a loved one works for a small business that does not offer insurance. Many small business owners would like to provide health insurance for their employees, but they find it too expensive. In fact, less than a third of employers with fewer than 50 employees offer health insurance. And so the proposed rule is aimed at a fix that would allow more small employers and sole proprietors to band together to create an association. And we can discuss, and I'm sure questions will come up about the overtime rule, the fiduciary rule, the Cranes rule, and the tip pooling rule. And a final word about tip pooling. I followed the public discussion on this issue, and let me just say I think it's unfortunate that basic facts are being misportrayed. And I say this without any antipathy, as I recognize that we're in a time where, unfortunately, overstatement sometimes triumphs over a desire to solve a problem. And so in the spirit of problem solving, let me just make something clear. No one is looking to take tips. There are simple problems to this. This is a question of law and a question of policy to some extent, but primarily a question of law. And so as we discuss this today, I hope we can focus on problem solving, and we can focus on what is actually allowed by law and not allowed by law, recognizing that this committee really has the authority to implement a solution to this matter. And so I look forward to your questions. I look forward to working with you, not only today, but as we go forward. I know that, I note the chairman mentioned that the budget is an ongoing effort, and that many of the rules that inform the budget are changing on a continual basis. And so I think that this is the first of many discussions. Thank you.
I want to thank you for your testimony, Mr. Secretary, and again, you hit it right on the nose. I'm sure we'll be having a lot of discussion back and forth as the budget continues to take shape for FY18. Let me move to an area that, frankly, the President's been very strong on, and that's the apprenticeship grant program at the department. Committees historically had some concerns about the underlying authorization, but Congress has provided 2 years of funding for the program, and I'd like to, frankly, build on what the President has proposed in your budget. So I'm going to ask two questions related to it. First, can you describe the current status of the Department's apprenticeship initiatives and how the Department would like to build upon and expand these initiatives in fiscal year 2019? And second, because we do have extra money, if we were able to find money above the $95 million that the FY17 budget authorized for the FY18 year, would you still have time to deploy that money efficiently, in your opinion, if we went above your current budget fairly substantially?
Mr. Chairman, thank you for the question. Let me take them in reverse order. First, as you're aware, the FY19 budget asked for an increase to $200 million above the $95 million because we believe, and the President believes, that this is a very important initiative. We are looking at several measures currently to further apprenticeships generally, and certainly if for fiscal year 18 additional money was put in that line, that is something that I believe we could make very efficient use of and would certainly welcome. Let me go to your first question, which is what is the current status of apprenticeship programs? And and I note the ranking member's comment about registered apprenticeship programs. And for some industries, registered apprenticeship programs work. But I have been in many meetings with dozens of companies that have said quite bluntly, we're not participating in the registered apprenticeship program. We find the registration requirements too onerous. We find that it is too decentralized, and we are not interested. And they have been very, very clear on that. And and ranking member, as I said, that is my observations, and so that's what we have been told. And so, without taking anything away from the registered apprenticeship program, recognizing that it works for certain industries, the construction industry being one of them, the President's proposal is to have a second apprenticeship program. He has directed that a task force be set up. That task force has been set up. That task force is in the process of adopting recommendations. At the same time, the President has directed that we implement an industry-recognized apprenticeship program. And conceptually, this will be in parallel to the registered apprenticeship program and will work like this. The registered apprenticeship program requires a lot of registration. It requires significant reporting, and it has access to certain advantages under WIOA by operation of law. That is the registered apprenticeship program. The industry-recognized apprenticeship program requires less registration. It would not require registration per se. It would require less reporting, but it would not have access by operation of law to those benefits that Congress has deemed to provide to the registered apprenticeship program. So you've got one program that requires heavy registration, that requires heavy reporting, and that has access by operation of law to WIOA. You have another program that doesn't require those and that doesn't have access by operation of law to the WIOA funding. And that is a balance that we're establishing between one program and the second program.
I appreciate that. I probably have time for one more, and won't be able to give you too much time, but your budget proposed significant reduction in Job Corps funding. Again, we know we're in a different situation now. We're going to have additional money. We may well be able to plug that particular hole. So, number one, your thoughts as to what we need to do funding-wise going forward, and if we were roughly the same kind of number that we've been at, how would you deploy that? Would you still go ahead with changes, or are there things that you would maintain that, again, your original budget forced you to abandon?
Thank you, Mr. Chairman. So there are two issues with the Job Corps. Perennially, I was speaking to a labor secretary going back many, many years, and I asked him about Job Corps, and he said that he had attempted to implement changes and had found that to be a challenge. And this is going back decades. And so I think this is a perennial issue. I recognize Congress's interest in Job Corps, and I understand why Congress has that interest, because it serves a population that benefits greatly from job training. And so if Congress, in its judgment, funds Job Corps at the same level, we will continue the Job Corps at the same level. Let me say also this in the brief time remaining. There are some issues in Job Corps that need to be addressed. We have a certain level of discretion to look at alternative mechanisms to conduct pilot programs within Job Corps. And irrespective of funding, it is my hope that we can engage in a discussion where we can look at the way Job Corps operates and we can say, how can we improve the operation of Job Corps? Because irrespective, I think at a bipartisan level, there are a number of issues that need to be addressed. We've gotten very, very strict on safety issues. There are ways that we can create efficiencies and that we can improve the program. The funding level is for Congress to determine. We will implement the funding level that Congress determines.
Thank you, and thank you for your indulgence. And I want to go to my good friend, the ranking member from Connecticut, for whatever question she cares to pose.
Thank you very much, Mr. Chairman. Just a very quick point on the apprenticeship program. Mr. Secretary, registered apprenticeships, that model has expanded over the last several years, about 42% since 2013. 2,400 new apprenticeship programs established in 2017 alone. I have spoken with industry groups as well, and different story. Standards are consistent and clear. Standards where they do not make sense for a newer industry, the Department of Labor is flexible, can and does negotiate. Also, I held a panel on apprenticeships, and Bridget Gaynor, who was vice president of Aon Corporation, commented on the ease of registration. Quote, it was not an overwhelmingly or overly onerous process, and they're in the insurance business. So there's differences of opinion, Mr. Secretary. Let me move to the tip sharing rule, which is where you ended your testimony. And the department has proposed a rule allowing employers to pocket really their workers' tips as long as they are paid for. Your testimony, you emphasized your commitment to providing regulatory, quote, clarity to the public. The department declined to release a study of the estimated impact on the tip-sharing rule on worker wages alongside the December notice in the Federal Register. EPI, Economic Policy Institute, developed its own estimates suggesting that tipped workers will lose about $5.8 billion in stolen wages. Women alone lose $4.6 billion. 67% of tipped workers are women. 3 or 4 questions. I'll pose them, but I want answers to each one. Why does the proposed rule not explicitly prohibit employers from pocketing their employees' earned tipped wages? Did the department conduct a quantitative analysis for this proposed rule? That's a yes or no answer. According to a report by Bloomberg BNA, department officials directed staff to withhold the disclosure of estimates which showed the proposed tip-sharing rule would cost workers money in lost tips. Is that report correct? Were staff directed to withhold this information? And can you explain why the data estimating the impact of the tip-sharing rule was not included in the original rulemaking notice? How can the department claim a commitment to providing clarity to a regulated public, but deny the public a chance to comment on the full effects of the proposed tip-sharing rule? And will you withdraw the notice of proposed rulemaking? Let's start with why employers are not prohibited from taking the earned tips.
So, Ranking Member DeLauro, I appreciate the questions, and let me say this, as I said at the beginning, no one wants establishments to keep, if you'll, I'll answer all your questions if you'll allow me to do so.
Sure.
No one wants establishments to keep tips. I wouldn't frequent such an establishment. My guess is that no one here on either side, Ranking Member, if you'll allow me to finish, I will answer all your.
You know, I have a limited amount of time, and the chairman will bang the gavel. So, why are employers not prohibited from pocketing their employees' earned tipped wages? They are allowed to do that under this rule.
Ranking Member, if you would like a short answer, I would refer you to the 10th Circuit's decision that struck down the prior rule established by the department on the grounds that it lacked statutory authority. If you will allow me to walk through this, I'm happy to explain why we are proceeding, why this is important, and at the end of the day, this is a legal issue where the 10th Circuit has made clear that the department lacks statutory authority, and so we're not in a system where we can.
So let me be clear. The fact of the matter is that in fact employers will be allowed to pocket the tips of their employees? Yes or no?
Ranking Member DeLauro.
Yes or no?
The department lacks statutory authority.
So the answer is yes. They can pocket those, the F. The second question is, did the department conduct a quantitative analysis for the proposed rule? Yes or no?
Ranking Member DeLauro. When the rule was initially written in 2011, there was no quantitative analysis published. The department looked at whether or not a quantitative analysis could be conducted. There are assumptions behind.
Was there an analysis conducted?
Ranking Member DeLauro.
I know my name. Was there an analysis conducted? Yay or nay?
Ranking Member DeLauro. If you'll allow me to answer, and I know we're over.
You know, Mr. Chairman, I will continue because I can't. I'm asking for short answers. I've asked short questions, and I'm not here to filibuster. Just tell me, yes or no.
Mr. Chairman, may I answer? Absolutely. So as I was saying, Ranking Member DeLauro, we looked at whether or not we could conduct an analysis that had assumptions based on data. We can establish at a national level what the level of tips and overtime are that are paid to all workers. Once that is established, we have to make assumptions as to what percentage of restaurants will actually have a tip pool. And of that percentage, what percentage of restaurants will actually make a decision that they would like management or others to keep a portion of those tips. Depending, Ranking Member, I'm now on my own time.
We're staff director to withhold the information.
Ranking Member DeLauro, I'm now on my own time, so if you will allow me, or I'm on the chairman's time, so if you'll allow me to answer.
The chairman is not going to allow me all this time, and I don't blame him. Thank you.
So once we establish the level of tips, there are assumptions that have to be made. Will 100% of restaurants choose to share with management? Or will 0% of restaurants choose to share that with management? Depending on that assumption, we can generate pretty much any number. And so at the end of the day, the determination was that the draft lacked sufficient data.
So there was really no quantitative analysis to deal with what you were doing, in addition to which this was information that when the rule was promulgated, this information estimating the impact of tip sharing rule was not included in the rulemaking notice. Is that correct?
I believe I have answered your question. It was a qualitative, not a quantitative analysis.
It was a qualitative, not a quantify. And if you can't quantify anything, you really don't have much of an analysis. So we have established that employers can pocket their employees' tips. We have also established that there was no quantifiable analysis. And in fact, I don't know what the answer is. We're staff directed to withhold the information. And you talk about providing clarity to a regulated public, but you then deny the public the chance to comment on the full effects of the proposed tip-sharing rule. Finally, will you withdraw the notice of proposed rulemaking? Yes or no?
No.
What I assumed. Thank you very much for your indulgence, Mr. Chairman. I appreciate it. Thank you.
I guess I'm glad to be here, Mr. Chairman. Yeah, I know. I started my career on the end of the podium, actually at the children's table. But Mr. Secretary, thank you, Mr. Chairman. Obviously, I want to welcome you. Apologies, we have Secretary Mnuchin across the corridor here, so I was with him. Just obviously want to thank you for your work, and I want to highlight, if I may, and ask you to respond very briefly. I know there are a lot of hot-button issues. I think you've taken some initiatives to address the needs of our nation's veterans. Can you talk a little bit about what the positive things you're doing here? I think all of us at the podium here, maybe this will give an opportunity for the temperature to be lowered just a little bit for a few minutes. Could you give us sort of an update of some of the initiatives you are undertaking to make sure that those who have done so much for our country have the jobs that they need in order to look after their families. If the chairman would allow me to ask that question.
Thank you, Mr. Chairman. And let me say that the needs of the veterans are very important and very much a focus of our work. And I'd like to highlight two programs in particular. The first is one that that Congress passed and authorized to begin, I believe, 1 fiscal year from now. But we're able to find a little bit of funding, actually, I think appropriated 1 fiscal year from now, but it is authorized, and we're able to find a little bit of funding to start it early, which is a recognition of companies that have a particularly strong record of hiring veterans. And we've already put out an invitation to apply, and we look forward to starting that recognition under Pilot Project Authority this year. We didn't receive funding, but we just thought it's so important that we get ahead of the game and get going before the funding that was appropriated start to recognize these companies. The second issue that I would like to highlight is occupational licensing. You know, if you're to look at various studies, from Federal Reserve-sponsored studies to Brookings, there are 1.5 to 3 million people right now that could hold jobs that aren't holding jobs because they are moving to states that don't recognize their current licenses. And this affects veterans in a particular way. A man or a woman may serve their nation, and they literally could be driving a truck with explosives in Fallujah, and then discover that when they end their service to the nation and want to come back to the U.S., they are not licensed to drive a milk truck in their home state. And that baffles me. I just don't understand why states are not willing to recognize military licensures and military qualifications. And so we're working very much with states through the National Governors Association. The Western Governors Association has been incredibly helpful in particular, and I want to single them out. And we've been working with them on a bipartisan basis because this is something that I think you know, I'd like to have someone explain to me why it has to be the way it is. It makes no sense.
In closing, it's amazingly frustrating because when we travel to the Middle East and other places, people are looking at retiring. They express their frustration that they've spent their time, they have these qualifications, and these barriers remain. So I want to commend you for your effort. I'm sure members of the committee feel very strongly, as I do, that this issue needs to be addressed as quickly as possible. Thank you, Mr. Chairman.
Thank you.
Thank you very much. We'll now resume the normal order of questioning. So, Mr. Womack, based on time of arrival, you're next. The gentleman from Arkansas is recognized.
I thank the chairman, and before I ask a couple of questions of the secretary, I feel a bit compelled to respond to my friend, the ranking member's tirade a minute ago about a company near and dear to my heart, Walmart. Since it is headquartered in my district, I find it interesting that too often my friends on the other side of the aisle cherry pick the issues that they'd like to complain about with regard to the Tax Cut and Jobs Act, and specifically to Walmart. It is true that bonuses were given to people on a tiered basis based on how many years that would make them eligible. But you failed to point out that Walmart also raised its starting wage to $11 an hour. That was not, I mean, apparently that's something good, and I wouldn't expect you to comment on something like that because it would defeat the narrative that you were presenting to this committee. An expanded parental and maternity leave policy providing full-time hourly associates with 10 weeks of paid maternity leave and 6 weeks of paid parental leave. Salaried associates also receiving the same benefit. And that Walmart will provide financial assistance to associates adopting children with a total of $5,000 per child for expenses such as adoption agency fees, translation fees, and legal or court costs. So if you're going to pick on Walmart, then tell the whole story. To impeach a company, arguably the world's largest company, the way you did, I think, was disrespectful. And let me also add that just in the state of Connecticut, the benefits totaled nearly $7 million to associates, to people in the state of Connecticut.
Will the gentleman yield?
No, I will not yield
Okay.
because I've got limited amount of time, and our committee is now shortened of time because of the 7 or 8 minutes that you took. So I'm just telling you.
I don't apologize.
It is absolutely incredible to me that that you want to be so critical of a company that employs over 1 million people benefited from these
155
changes
people
at
in Orange,
Walmart.
Connecticut lost their job when Sam's Club
Mr. Chairman,
closed down. Mr.
the
Chairman.
committee should be in order.
It is in order.
So I won't belabor the point, but to be fair, you should tell the whole story. Mr. Secretary, it's great to have you here today. We appreciate your testimony. In your testimony, you talked about the ongoing collaboration with Secretary DeVos to ensure that American workers receive the highest quality services available, and I am very pleased that we are beginning to address what we all know as the skills gap. Everywhere I go in my district, I have job creators telling me that they need people with certain skills, and I'm pleased that our Congress is beginning to take steps to address these skills gap. And personally, I believe that we made a mistake by trying to convince so many people that over the last generation or so that their only path to success would be with a college education. So we've got a lot of things. So would you care to elaborate on this, on the cooperation that you have with Secretary DeVos, and touch on how Congress can be of assistance? And I know I've got a limited amount of time left.
Sir, thank you for the question. And first, let me note that you know your state's unemployment rate is below the national average, and so the skills gap's a particular issue. And I believe it's your home state that has a program called Go Pro, Go Proud.
It is.
And I have seen the videos of that, and let me just commend that because I think it does a great job of exposing young adults to the full array of their career options. And this is what Secretary DeVos and I are really focused on. As young adults go into high school, are they being given the full information? Are they being told, these are all your career options. You can go in this direction. This is the amount of higher education that you will need. This is the expected salaries, and this is the expected student debt. Or you can go in this direction, and this is the amount of additional education you'll need, and this is the additional student debt. And I would contend that that our counselors, particularly at the high school level, are not doing a very good job of that. I was in one state where I was speaking with the vice chancellor of a state school system, and I raised that, and he said, "Mr. Secretary, you're absolutely right. We're focusing far too much on the top-end students, and we should be focusing more on SAT prep and ACT prep." And I kind of looked at him and I said, "You just completely lost my point. The vast majority of Americans don't get their jobs based on SAT and ACT prep. And we need to encourage high schools to provide the full array of options to the students. And that's something that the Secretary and I have been collaborating on. And let me just say it's a great collaboration. So thank you for the question.
Thank you, Mr. Secretary. Appreciate your testimony. Keep up the good work.
Thank you again. Based on order of arrival, we'll go to my good friend from Wisconsin, Mr. Bocan.
Thank you, Mr. Chairman. Appreciate it. Thank you, Mr. Secretary, for being here. I'm trying to get to 4 areas. I'm already predicting I'm going to fail, but I'm going to do my best, and I'll try to, if we can be brief in both ways,
Fair
I'd
enough.
appreciate it. First question on OSHA. There was a news report earlier in the year. There was a 4% decline in OSHA inspectors since the president's taken office. They've lost at least 40 inspectors, I think is the number, through attrition, and no new hires had been filled as of October. Can you tell me, one, hopefully they're all easy, have you hired the new OSHA inspectors to fill those 40 slots? Two, are all the OSHA inspector positions currently staffed? And three, have we maintained a total number of inspections from 2016 to 2017 to 2018?
So, Congressman, thank you for the question. Let me try to address those briefly. You are correct that there was a decrease in the number of OSHA inspectors. I became concerned about that decrease last summer. And so, although there was a general hiring freeze in place, I provided OSHA an exemption to start the process of hiring inspectors. And currently, I believe there are 65 recruiting actions in progress. at various stages of the recruiting process. There's an onboarding procedure for OSHA. They have to undergo physical examination. They have to undergo others. In addition, I've encouraged the agency to hire more than is currently, than the current FTE, understanding that, that we need a continuous pool. Finally, on the number of inspections, I believe I cited in my opening, this is the first time in 5 years that the number of inspections has actually increased year over year. So despite this, there have been no decreases in the number of inspections.
And just real quick then, do you know of those empty slots, how many, you had 65 actions, how many of the 40 slots have been filled, or are they part of that in the process of?
It is in the process. I don't know where,
Fair enough.
where it is as of today. I know that I authorized them to begin hiring this past summer, and they have proceeded in the regular process, and we can provide that information.
No problem, thank you. I'd also like to submit into the record 2 stories, if I can, about federal contractors driving down wages for workers and routinely committing wage theft while not seeing their federal contractor status even reviewed. One, the headline is, "Workers who really do support our troops are getting their wages slashed." I would just ask if you could take a look at those, and if you could give them a little extra attention. You know, I'm just a little bit concerned that some of our compliance assistant versus enforcement may not be working as well, and these are just 2 recent articles.
Just without objection.
Sure. Thank you very much.
Gladly, and we'll have, we'll make sure that our staff communicates with yours to receive those.
So issue 3, we're doing pretty well. On a lot of the efforts that you and both the President have talked about around deregulation, there's been a lot of deregulation in your department around things that protect workers' wages, overtime, health and safety, pensions and health care, civil rights, and other areas. Yet we've ramped up regulation at the Office of Labor Management Standards, specifically a 22% increase, including $2.8 million to restore the International Union Compliance Audit Program, which has been used in the past to actually harass labor unions. I'm just wondering why unions are the only group that seems to be singled out for more regulation when everything else has been moving towards deregulation.
Congressman, first of all, I think we're referring to the budget because we haven't had new regulations issued out of that office. But the budget on the enforcement agencies is pretty much the same as it's always been. The one office that you have referred to was, unlike other offices, was substantially reduced over the prior years. And so this is an attempt to bring it up to what are historical levels.
Okay, but the only one that you're adding to regulation. So which 2 are you getting rid of? Because isn't it, if you add 1, you have to take away 2? Isn't that the informal rule your administration has?
We're talking budget here, and we're not talking, I'm not aware of.
Okay, so you can budget more regulation, just you can't.
Congressman, as I've gone through, you know, I think the enforcement record, and I went through the facts to address the narrative, which I think is a false narrative of any decrease in enforcement. And if you look at the budget proposal, even though there, if I could.
I understand, you know, I think I understand. If I can get my last in, I'd be so successful. So if I can just get my last, and I'll try to do it really quick.
Fair enough.
Thank you. Just some concerns around, you talked about reevaluating the laws around the Labor Department for the gig economy you refer to as entrepreneurship. We have some concerns that the direction you might be going could take away protections for people like Uber and Lyft drivers and Amazon delivery drivers, that they might not get paid minimum wage and other things. Can you just talk very quickly about that? I appreciate it.
Congressman, certainly, and I think what I've said, to just put on the record, is the Bureau of Labor Statistics is coming up with is going to be issuing a study on alternative work arrangements on the gig economy, the entrepreneurial economy. And I think that study is an important marker to start a national discussion on what is a larger percentage of the economy. And so I think, let's start with the agreement. We all should be having that discussion. It should be a fulsome discussion, and it should look to assure that there are protections in place, while at the same time there are access to benefits that are not traditionally afforded these individuals in these work arrangements.
Okay, great, and thank you for helping me be successful.
Well, you got a little help here too, my friend. If we can, I next want to go to my great friend from the state of Tennessee, Mr. Flashman.
Thank you, Mr. Chairman. Mr. Secretary, thank you so much for appearing today and for your testimony. I represent the great people of the 3rd District of Tennessee, from Chattanooga to Oak Ridge, 11 wonderful East Tennessee counties. Personal note of thanks, not only for the rhetoric and policies of this administration in regard to the Department of Labor, but to the successes that you've had, and I think you have aptly stated those, so I thank you for that. Several years ago, right after my first term, I began a workforce development initiative in my district. I was trying to find something that not only Republicans and Democrats could sit around the table, but we could have employers, employees, educators, and civic leaders, and there was a need for that, and there still is. So that has really been my main focus in this area of jurisdiction. So I want to applaud you for your efforts in that regard, and I want us all to continue to work forward as Americans. I think when employers and employees can work together, America does move forward, and I come at the process in that regard. I do have a question. Mr. Secretary, there are 4.9 million American youth between the ages of 16 and 24 who are neither in school nor employed. As you know, the $1.7 billion Jobs Corps program at the Department of Labor is the nation's largest residential job training program for at-risk youth between the ages of 16 and 24. And yet, there seems to be a mismatch between the training that is offered at Jobs Corps centers across the country and the actual jobs that are in demand and expected to grow in the market. For example, in 2015, the Department of Labor issued a joint jobs report with the Department of Transportation and Education that found that transportation sector will need to hire 4.2 million new workers by 2022, and that the trucking industry in particular has by far the largest number of projected job openings at over 2 million jobs that need to be filled in that spot. Yet, according to the Department of Labor's website, only 4 out of the nation's 122 federally administrated Job Corps centers offer any type of training in heavy-duty trucking. Mr. Secretary, do you know why truck driver training is limited to only 4 Job Corps centers, and would you kindly consider expanding the number of Job Corps centers that offer truck driver training, sir?
Congressman, thank you for the question, and let me address it on a few levels. First, I do not know the why, but I will gladly consider. More broadly, this goes back to the point that I mentioned with military training. If you're licensed to drive a truck with explosives in the military, why can't states recognize that license when these service members come home? That is a no-brainer. Let me say more broadly on Job Corps. I would very much like the opportunity to sit down on with individual members and start discussions about the Job Corps in their particular states. Right now, Job Corps is a very large national program, and it is operating the same way it operated as far back as the 70s. I had the opportunity to visit a very different model. I was in Nevada, and I had the opportunity to go to, I believe it was Truckee Meadows Community College, and that community college was working with a program called Youth Build. And I talked to some of the students in that program, and then I asked the administrators to sort of leave the room. I put on my old prof hat and just talked to the students directly. And I was really moved. One of the students said that they had been on the streets, that they had been taking drugs, that they had seriously thought about ending their life. And then they found the Youth Build program that is working with this community college that is also working with businesses, partnership between education and business and Youth Build. And here's what they were doing. He was learning to be an HVAC certified repair person. For the first time, he had an apartment. He rented an apartment, and he was really proud of that. And this program per capita is a lot less expensive than Job Corps. And so one of the questions that I think we need to ask is not an elimination, but an asking, is the way that educational services through Job Corps was provided in the 70s the best approach? Or should we be looking at alternative mechanisms within the Job Corps system, perhaps changing what is taught, perhaps changing the age range, perhaps changing the length of study? And it doesn't have to be the same for every Job Corps around the United States.
Thank you, Mr. Secretary. Mr. Chairman, I believe my time is up, so you'll back.
Done better than anybody else so far. Cam, we'll go to my good friend from Massachusetts, Ms. Clark.
Thank you, Mr. Chairman, and thank you, Mr. Secretary, for being here today. I want to go back to the issue you were discussing with the ranking member around tips. And I was struck by what you said, that you wouldn't frequent a restaurant or a place where management was taking the tips from tip workers. How would you know that was happening?
So in the era of Yelp and the internet, I think it would get out very quickly. And personally, I don't think many restaurants would do this because they'd lose their workers and they'd lose their customers.
Have you ever
bad
worked for
thing.
tipped wage?
No, I have not.
Well, I think I have. And I can tell you that I doubt very much you would know, because there's a lot that goes on. But you're in a unique position to help, because the tip wage in 18 states is only $2.13. That's also the federal tipped wage. Excuse me. It's double the rate of poverty in states where that's the tip wage for working people who are working for tips. And if you're wait staff, that's over double. It's 18% when it's typically 7% for working people in poverty. So we're talking often about the working poor. So as you go through this in your role as secretary beyond Yelp, and you're looking at doing, I hope, a quantitative, since you found the qualitative not to be good enough as you go forward, what are your plans for assessing the impact on this? And if you are finding that it is not working out as you hope and that these tips are being pocketed, what is the plans for the labor?
So Congresswoman, if you'll allow me to answer and perhaps offer a fulsome answer, because I think with about 2 minutes, we'll get to a point where we might agree. No,
I have other questions, so we may have to go faster.
Well, I'll try to go fast. No one wants or believes that establishments should keep tips. In many ways, this is a fundamental issue of law. The 10th Circuit has struck down the prior regulation that was promulgated. The 9th Circuit has upheld it over a vigorous dissent, and this issue is now pending in the Supreme Court. And so the question is, has Congress authorized the Department of Labor to regulate in this space? And we can have a legal debate, which I don't want to have. But personally, I find the 10th Circuit decision persuasive. I believe that Congress has not authorized the department to fully regulate in this space.
So let me synthesize this so that we do come to some understanding on this. There is a split in the circuits on this, but is my understanding that your position is, now that you have put this in place, remove protections for tip workers, that you are not going to conduct any further analysis of this because you feel the 10th Circuit has blocked you from doing that?
If you'll allow me to finish. Can
you answer that question? Do you feel the 10th Circuit has blocked any further analysis of the impact of this rule?
Congresswoman, I will answer
or no?
questions if you allow me to finish.
Yes or no?
Ultimately, I've already said publicly that any final rule will have a quantitative analysis. I've invited the public to provide data for that quantitative analysis. But let me say this, there's a real simple solution to this, which is that this committee could simply legislate our authority to prohibit this. And so if we're all concerned about this, why don't we just add a simple sentence to the law that says that establishments, whether or not they take a tip credit, may not keep any portion of the tips. I don't know of a single person that would oppose a law that says that an establishment may not keep part of a tip.
So you would support us
100%.
in a law that says, so you feel you are totally bound by the 10th Circuit right now?
Well, the Department of Justice would determine whether I'm totally bound. My personal view is I find the 10th Circuit persuasive.
Asking your view as Secretary of the Labor Department.
My personal view
Would you support a law coming out of this Congress saying that tips belong exclusively to those who earn them?
Absolutely. OMB put that on the list of items to be looked at as part of the appropriations process, I believe, about a week ago. And so that's already been on the list that's been transmitted by OMB. And the point that I was trying to make that I think we can find agreement and problem solve on is no one wants this. This is a question of statutory authority. So I fully support a provision that says establishments should not be permitted to keep any portion of a tip.
But yet you're siding with the 10th Circuit and taking our entire policy in a different direction, which I am running out of time, so we can have this legal debate later on. But I think that we need some assurances from you, one, that you would support such a law, which you just gave, and two, that you will continue to conduct a robust analysis of the real impact, because this affects working people and their wages
Assured
in
and
a profound
assured.
way.
That what I've been trying to say is assured and assured, yes.
Thank you, Mr. Chairman.
Thank you very much. And just for the gentlelady's information, we actually had this discussion. The Secretary has requested that we put something like this in language. I certainly would be very supportive of doing that, and I think we'll probably be able to get there on this. So anyway, I want to thank everybody involved in a vigorous discussion. With that, I want to move to my good friend from Maryland, Mr. Harris.
Thank you very much. It's good to see you, Mr. Secretary. Let me just clear up a couple things, and just one thing on the tip thing, and I agree, I'll be on board with that, but did you say that there was no quantitative analysis when the last administration did the rule?
That is correct.
Oh, okay. Oh, I get it. All right. All right. Now, the other one is that OSHA, let me get your testimony right, that OSHA, for which we're hearing complaints that, this OSHA's, can't do the job, you actually increased the number of inspections, which hadn't been gone up for the last 4 years of the last administration?
For the last 5 years, they had.
Oh, I'm sorry, for the last 5. I have to change my notes. It's 5 years, not 4 years of the last administration. Okay. I want to thank you for the EEO1 rule. The EEO1 was a boondoggle. I mean, it was that form that the department held up. As you know, this committee's taken a position against implementing that. Please think it out better. There have to be better ways to get the information than the EU1 suggestion. I want to thank you for taking a second look at the overtime rule. As you know, the real people who get squeezed are the people who are kind of who are on that job ladder, who are climbing the job ladder, going to have to prove that they are that they're worthy of getting up to the top. And I think it impeded them getting up to the top. So thank you very much for that. Now let me talk a little about health insurance, because something I think frequently about, and it's the Affordable Care Act individual exchange is collapsing. Look, we'll have to admit it's collapsing. Congress can't fix it. I mean, we just didn't have the will or whatever to fix it. Things stalled over in the Senate, so it's going to be left up to the administration and to states to solve this problem. Now, in Maryland, we have bills before our legislature right now doing what we had proposed, which is set up either a reinsurance pool, which is what's going to be done in Maryland, high-risk pools. But until you get there, I think the association health plans are the way to go. I think that I think your testimony was that less than a third of employees with 50 or less employees actually offer insurance. And I think employee-based insurance actually has a lot of things to say for it. So it would kind of it would give the ability of small employers to actually offer insurance as a benefit of working for that individual. And I think that's a good idea. It would remove some of these are not junk plans. I mean, most people who get insurance through their employers are very happy with the plans. To call anything except an Affordable Care Act plan a junk plan would say that before the Affordable Care Act, every plan was a junk plan, because no plan in America would have qualified under ACA before the ACA was implemented. So I want to thank you about that. But the issue that I'm most interested in, because you were nice enough to take a meeting with me in the office, and that is the H-2B issue, the issue of temporary work visas. On the front page of your testimony, and it's correct, the good news is that we got a lot of jobs. We got a lot of people working in this country, and our unemployment rate is very low. The number of workers is high. The bad news is that your last point in November 2017, number of job openings was 6 million, near an all-time high of 6.2 million. We got a lot of job openings. We don't have people to fill those jobs. In my district, H-2B workers fill a vital role in seasonal employment, whether it's in beautiful Ocean City, whether it's in the tourism industry, whether it's in the seafood industry. People, you go to meetings around here, they love to have those little crab cakes. somebody's got to pick that crab, and the experienced workers are H-2B workers. And unfortunately, as we have discussed, there are 33,000. The quote is 33,000 for the second half of the year, which is the summer season coming up. 88,000 applicants. That means 55,000 workers could not have been hired. And I'm hearing on a daily basis. I had a telephone town hall last night. 2 calls. Please do something about it because it's so vital to my neck of the woods. Could you outline where you see these temporary worker programs going in a setting of full employment?
Congressman, thank you for the question. Let me in 1 minute offer maybe three ideas. One, the current H-2B program is limited by congressional mandate to 33,000 in this 6-month period. In the first day alone, we received applications for more than 80,000 visas. If you break it down by industry, I particularly feel for the small businesses in districts like yours that have highly seasonal businesses, where the local workforce demand cannot be met by the local workforce population. And to me, that is the core of what H-2B is about. If you look at the businesses that are making use of H-2B, I'm not sure that all the businesses that are using the program are as highly seasonal as the ones that you cited. And but I don't have discretion to pick and choose between businesses I process as they come in. And so Congress is going to have to make a decision whether or not to address this issue. One final word. Last year we asked for a fee as part of the budget. We're asking for that fee again as part of the budget to simply streamline the process. We are literally using snail mail right now for the application process to go from agency to agency. And this is a simple, good government solution that would benefit everyone regardless of caps. And so I know as a general matter, Congress dislikes the fee-based process as opposed to the standard appropriation process. But for the sake of all the individuals, and I can describe the process in more detail later, that use this process, it's time to modernize. And so I'd ask that the subcommittee look at the fee request again.
Thank you very much, and I hope you work with us on that. Thank you, Mr. Chairman.
Absolutely. Next, go to my good friend from California, Ms. Lee.
Thank you very much, Mr. Chairman. Welcome. Good to see you, Mr. Secretary. Now, I want to hear your understanding of why President Trump touted the supposedly low unemployment rate in the black community that he claims is only because of his policies. I want to hear what those policies were, because this statement couldn't be further from the truth. Let me put this in for the record. Black unemployment is double that of whites at 6.8%, which is the highest among all racial groups nationwide. Latino unemployment is also high, around 5%, compared to 4% nationally and 3.7% for whites. It's not just unemployment, Mr. Secretary. Black full-time workers earn less than 60% of what white workers earn every year. The median net worth of white households is also 10 times higher than that of black households. And so here we have a president really trying to take credit for the lowest black unemployment and economic gains. But this happened long before he took office in terms of the trajectory. Black unemployment has been declining since 2011. For the record, black unemployment rate fell from 16.5% to 7.8% from January 2011 to January 2017. Now, the Kerner Commission issued an updated report citing what is taking place now, 50 years later, as it relates to income and racial justice and inequality. 50 years ago, African-American unemployment rate was 6.7%. Now, today, it's 6.8%. Mr. Chairman, I'd like to ask if I could insert this updated report into the record.
Without objection.
It's called Healing Our Divided Society. And let me just read one paragraph. In Healing Our Divided Society, Fred Harris, the last surviving member of the Kerner Commission, along with Eisenhower Foundation CEO Alan Curtis, they re-examined 50 years later the work still necessary towards the goals set forth in the Kerner Report. That's 50 years ago. This timely volume unites the interests of minorities and white working and middle-class Americans to propose a strategy to reduce poverty, inequality, and racial injustice, Reflecting on Americans' urban climate decline, this new report sets forth evidence, policies concerning employment, education, housing, neighborhood development, and criminal justice based on what has been proven to work and not work. And so, Mr. Secretary, I want to ask you, would you review the recommendations in this report and provide the committee your feedback on these recommendations and which ones you think could be adopted by this administration? And secondly, just with regard to your budget, that slashes a lot of the critical job training programs. We talked about the 24% cut for Job Corps, 34% cut for dislocated worker National Reserve funding, 10 million cut, that's 11% for reintegration of ex-offenders back into the workforce. So don't you also believe we need targeted investments in communities of color where this unemployment rate is still twice the national average? So I want to hear what you intend to do, what you are doing, and why in the world are you, is the president at least, misrepresenting the facts?
Congresswoman, thank you, and let me try to take those seriatim. I will gladly review the report, and perhaps you and I can even sit down and talk about this.
I'd love to do that.
And I'd very much enjoy the opportunity to sit down maybe with you and talk about it in more detail. With regard to the second question, I understand all the concerns, and I certainly understand your points, but the fact is that since the series has been kept, I believe it was either in November or December, it did hit the lowest level since the series was initiated back in, I believe, the 70s. So that is just a factual statement, which is 100% accurate.
That was not under this president's policy.
And I would add, because I've heard statements that President Trump is not responsible for I've heard statements that I think are inaccurate, that President Trump's not responsible for the economic gains. But if you look at the breakdown of the industries where we've had the greatest acceleration in growth, those industries tend to look like construction and manufacturing, and all those industries that the president has focused his energy on. And so the acceleration in growth has been highest in those industries, which I think points to the fact that, in fact, it is the change in policies that has spurred the economic.
But in those industries, you have very few African Americans and Latinos, Mr. Secretary. All you have to do is look at the workforce in those industries.
Happy to engage in this session.
Okay, well, do we have a second round, Mr. Chairman?
If we
don't,
can hold it down in the first round, we're
Okay,
going to do our
thank
best.
you, Mr. Secretary. I look forward to sitting down with you.
Thank my friend from California, and I just want to note for the record, Fred Harris is from the 4th District of Oklahoma. Before he was a United States Senator, he served as a state senator for the second largest city in my district, so proud that you quoted him. With that, I want to move, the ranking member of the full committee has arrived, and we're delighted to have her here as always. We consider her really a member of this subcommittee, as she is of all subcommittees, but we know we are her favorite. And so we're delighted to have her here, and we recognize her for any comments or questions she cares to
you're very
offer.
kind. This is, I better be careful. This is a very important subcommittee. I've been part of it for a long time, so it's always an honor to work with you and to all the outstanding members. I really want to thank you, Mr. Secretary, for joining us today. We have multiple hearings this morning. I'm so sorry I missed your testimony. I know that important federal investments in worker training, apprenticeships, and more have been discussed. And I'd like to raise a matter of great importance to one of my constituents. In 2001, Special Agent Terry Opiola was serving in the U.S. Customs Service, where he was part of the rescue and recovering team deployed after 9/11. Mr. Opiola spent nearly 600 hours at Ground Zero and the Fresh Kill landfill, digging through rubble in search of missing case evidence, exposing him to toxins that have caused great harm. Mr. Opiola was diagnosed with chronic lymphocytic leukemia, or CLL, in 2015 by physicians at Mount Sinai's World Trade Center Health Program. The physicians at Mount Sinai categorized CLL as a form of cancer and a recognized category of World Trade Center-related health conditions. Mr. Opiola is now being treated by the World Trade Center Health Program, affiliated oncologists at New York's Memorial Sloan Kettering Hospital. And yet, the Department of Labor has denied his application for disability, stating that the department has not found a causal relationship between his cancer and 9/11, even though the experts at the World Trade Center Health Program, OPM, and the Department of Justice Public Safety Officers Benefit Program all recognize the relationship. In November, I led a bipartisan letter with the original sponsors of the 9/11 health bill to bring this matter to your attention, and we are yet to receive a response. In recent months, Mr. Opiola has been going back and forth with the Regional Department of Labor office, who have asked him for documents he has already provided and given unclear instructions which have amounted to unnecessary delays. This man gave everything he could to our country in a time of crisis, and it is frankly unfathomable to me that his case would be stuck in a bureaucratic mess. So I implore you to fix it. A few questions. Why is the Department of Labor not recognizing a causal relationship between these types of cancer and 9/11 when the medical experts and other federal government agencies have already determined the cause? And if you can respond about what you're going to do to fix it.
Ranking Member, thank you very much for that question. I can't respond to the specific case, but I think I can address the point that you're making. First, if we haven't responded to you, I feel very strongly that we should respond in a timely manner, and we'll make sure we get a response to you this week. Secondly, I have been disturbed personally by the confusion in the standards in various programs that the department administers, particularly as it affects first responders. I have asked staff to look at this and to give me an explanation, because the questions that you ask, I have asked myself of staff. And as we've looked into this, we have seen that as Congress has developed various programs over time, each one has a different standard, a different causal relationship that must be established, a different set of discretions for presumptions that we can make. Personally, as I look at this, these are individuals that have served our communities, that have served us, and I think to the extent that we can, we need to help them. I would very much welcome the opportunity to sit down on a bipartisan basis. And, there are several statutes with several different standards that must be met. And I think it's incredibly confusing because the American citizen out there that is applying doesn't understand that if you apply under this statute versus that statute versus that statute, there are different requirements. And I think it would be a wonderful thing for Congress to look at these, and let's bring some sanity to the different standards by maybe harmonizing the standards so that first responders, irrespective of what program they fall under, can all have the same access to benefits, and the recognition that as a statistical matter, much of what they are suffering is because they actually acted as first responders serving the people of our nation.
Let me just say this. I'm glad you're going to do a lot of studies, and I'm glad you're going to fix all the programs, but right now the relationship has been established, so just fix it, please. Thank you.
Congresswoman, if I could, I have to follow the law. You set the law. I will gladly speak with you about harmonizing the statutory standards. I don't have authority to change statutory standards, and that's the problem.
I'd be delighted to have a discussion with you anytime about statutory standards, but the relationship with this man's illness clearly has been established, so I would hope you would take your executive action and fix it, and then I'm delighted to have meetings with you at any time. Thank you, and thank you, Mr. Chairman.
I thank the gentlelady. We next go to my good friend from the great state of Alabama, Ms. Roby.
Thank you, Mr. Chairman. Thank you, Mr. Secretary, for being here. Dr. Harris touched on the topic I want to talk about. The Department of Labor's FY 2019 budget request provides expanding access to health coverage by allowing more employers to form small business health plans or association health plans. This initiative is supported by increasing funding for the Employee Benefits Security Administration to develop policy and enforcement capacity to expand access to small business health plans. So as you know, Obamacare is currently the law of the land on health care, despite numerous attempts by my colleagues in the House to completely repeal and replace this ill-conceived law. However, we were able to repeal the individual mandate required under Obamacare so that individuals will no longer be assessed a penalty if unable to maintain coverage. While this is a step in the right direction, more reforms are necessary. Obamacare is riddled with burdensome regulations that hinder states across the country in providing affordable health care options to their citizens. Many from Alabama and throughout the country have shared their stories of insurance policy cancellations, skyrocketing premiums or copays, and new limitations on what physicians they can see. In my state of Alabama, there's only one health insurance provider. There's no question that America's healthcare system is in need of dire reforms. So, Mr. Secretary, it's my understanding that the administration, and in your testimony, you mentioned the proposed rules expansion of association health plans will increase access and provide more affordable options. Could you provide this committee with a little bit more detail about how the proposed small business health plans or associated health plans will work, and how they will help relieve some of the strain caused by the burdensome Obamacare regulations? And then also, how much flexibility will these small business health plans allow for?
Congresswoman, thank you. Thank you for the question, because this is a very important issue. And so under ERISA, the department has regulatory authority to determine what is a commonality of interest so that businesses can associate in providing things like healthcare. And so the concept behind the association health plan or the small business health plan is that businesses that have a commonality of interest can come together and they can negotiate for health as a group, for health insurance as a group. And so, I was talking to a small business person about this that went from 60 employees to 40 employees. And they pointed out how much more expensive the small group market is than the large group market. Same health plan, but an increase in premiums. But if all those small businesses can come together and access that large group market, a few things will happen. First, they have an economy of scale. Secondly, most small employers aren't in the business of negotiating health care. They're in the business of running their small businesses. And so this would allow them to come together and have an association that they would control. If we proceed with this proposal after notice and comment, that they could come together and then have experts that are much more focused on how to negotiate healthcare. And I believe that very change that creates an economy of scale and that allows an expert to actually negotiate the plan on behalf of a large association would be important steps in driving down the cost of healthcare. So small businesses can offer employer-based healthcare to their employees and their families. Nearly 11 million individuals working for these small businesses that don't have access to healthcare.
And I can just say that we get calls all the time. There's so many people in my state, and I'm sure throughout the country as well, that have an insurance card in their pocket that they can't afford to use. So just please know that you have my full support as you develop these policies that will increase choices and return health insurance decisions back to where they belong with the doctors and the patients. So thank you again for your leadership. I appreciate you being here, Mr. Chairman. I yield back.
Thank you.
The new champion, under time, not even close. We'll now go to my other good friend from the great state of California, Ms. Roybal Allard.
Thank you, Mr. Chairman. First of all, let me just associate myself with the concerns that have been raised regarding the rule on tips, and also with regard to the $1.1 billion cut to the Employment and Training Administration. Secretary Acosta, when you testified before the subcommittee last year, I expressed concern about President Trump's executive order to revoke the 2014 Fair Pay and Safe Workplaces order, which prevents companies with government contracts from using forced arbitration clauses to keep sex discrimination claims out of the courts and off the public record. 5 months after that hearing, we learned of the widespread use of forced arbitration clauses by many industries to hide sex discrimination and sexual harassment in the workplace, and such revelations gave birth to the Me Too movement. Last year, you noted that as a general matter, federal policy favors arbitration. So I'm not contesting that, but I would like to specifically focus on forced arbitration because there is a difference between an employee choosing arbitration and an employer forcing arbitration to silence victims and conceal a corporate culture where sexual harassment, sexual assault, and discrimination may be commonplace. So my question to you, Mr. Secretary, is do you believe that companies with government contracts should be able to use forced arbitration clauses? And since the arbitration is done in secret and unavailable to the public, how can you protect others from being vulnerable to the same types of abuses? And how can you protect the rights of victims, especially from retaliation from their employer?
Thank you, Congresswoman. I believe what you're referring to is an executive order that that said that companies that had violated certain rules could not be, as a matter of law, or should not be, as a matter of law, prohibited from engaging in the contracting process. Now, your question goes to whether or not arbitration, there should be arbitration provisions, from what I sense, arbitration provisions in employment contracts. Is that what your question?
Yes, I'm referring to forced arbitration that some companies have.
So when you say forced, is that a contractually agreed to arbitration?
Yes.
And so federal policy for decades has favored arbitration, and that includes arbitration agreements that are part of a contract where individuals agree in a contractual relationship that they will use arbitration. Certainly, that's something that we can discuss and that we can look at, and whether there should be further discussion on that. But that is something that has been part of federal policy for decades.
No, I understand that in general, but I guess what my question is what is your opinion with regards to forced arbitration with companies that have government contracts, since it has been shown that it is used to hide a culture of either discrimination, sex abuse, and so on.
And I guess here's where my confusion's coming in. When you're saying forced arbitration, is that the same as contractually agreed to arbitration?
Yes.
And so when arbitration is contractually agreed to, you have two parties coming together and contractually agreeing to engage in arbitration as a recognition that the legal system can be very expensive, and that arbitration is a less expensive, more affordable remedy. Now, there may be protections that we should be looking at within the arbitration system.
Let me ask the question another way. Do you think that companies that have these contractual agreements of forced arbitration should be given federal dollars?
Well, Congresswoman, I believe most companies out there have arbitration clauses in all sorts of relationships, including employment, and federal policy has for decades. So that would be a drastic change from established federal policy that has been in place for decades and decades. And before we go down that road, I would want to have.
Are we still talking strictly about forced? I understand.
We were talking about
arbitration, and I'm not
contractual, yes,
contesting that.
yes, and I would want to have a discussion about whether there are procedures that perhaps could address your concerns within the arbitration process before we go down
Because
that
my
road.
understanding is that in order for an employee to get a job, they need to sign that contract that includes the forced arbitration. So I'm talking about forced arbitration and companies that receive federal money. So I would very much like to maybe talk about this further and see if there is something that can be done, because it really just opens up the doors for abuses and leaves employers very vulnerable to what is happening in that company.
Happy to have the discussion.
Well, thanks, gentlelady. We now go to my good friend from the great state of Michigan, Mr. Molinar.
Thank you, Mr. Chairman. Mr. Secretary, can you see me? Yes. There we go. I wanted to follow up on some of the discussion we were having on the H-2B visas. At the core of your response, I got the sense that you said Congress needs to take action to make changes there. I guess one of the questions I have is there anything you can do unilaterally to make changes that might help this situation?
Congressman, this is pretty straightforward. Congress has said that there's an annual cap of $66,000 that is divided into two parts of $33,000 every 6-month period. For this $33,000 period, we received 81,000 requests. Congress has given us that number, and if that number is to change, it needs to initiate here. One issue that I want to highlight, however, is we don't have discretion as to how these are issued. There are some industries that are highly, highly seasonal, where for a few short weeks you have a large peak in demand, larger than the local workforce could possibly cover. That, to me and to my mind, is what the whole concept of that seasonal visa is about. There are other industries that, while they're seasonal, they don't have that one peak. And they're spread over a larger geographic area, so they don't have as big a strain on the workforce because it's spread out over large swaths of the country. And so one of the concerns as Congress looks at this is, are you really focusing on those highly seasonal industries? And should there be any distinction between the highly seasonal industry, where the local workforce is simply insufficient, and other seasonal industries that are taking up a large portion of these visas? That ultimately is a question for Congress as how you set those standards. And the second point that I'd make is currently the Department of Labor has a system, the Department, DHS has a system, and state has a system. And we have asked for a fee to integrate those three systems so that, much like we see in our telephone apps, someone can apply and track where it goes from agency 1 to agency 2 to agency 3. I think that's a simple good government thing that everyone should be in favor of. And so I believe, we might have the opportunity to receive a little bit in this year's budget to start that process, but that fee long-term to fund that streamlined system, I think, is something that I would ask the committee to look at again.
Just a follow-up question. So when you issue certifications for H-2B workers, for instance, my understanding is your department, as of February 27th, had issued 59,537 certifications for H-2B visas, for H-2B workers. Does that mean that your department has sort of verified that there are not employees that are available for those jobs, U.S. employees, and that it kind of certifies that that is in case needed?
So that is not the case. And let me briefly walk through the process. Someone that is looking to hire an H-2B worker would apply to the Department of Labor. We would certify the wage rate that they're offering as an appropriate wage rate. We would then send them a notice, and they would then advertise. They would show us proof that they had advertised, and then we would then certify that they have met the advertising requirements. At that point, the individual seeking the visa would then send the request to DHS, which is the one that would then process that visa, send it back to the individual would then send it to the Department of State for issuance. And so our role is to certify the wage and certify that they have met the advertising requirements. And we will certify all the individuals that apply, whether or not the cap has been met. It's our policy, because we don't know if Congress is going to change the 33,000 cap, so it's our policy to certify the individuals that have applied, whether or not the visa cap has been met.
And for someone to come up with a new cap number and to have that kind of support within the administration, if we were going to work on that in Congress, who would need to be in the room to have that agreement that this is what is needed for? Because I'll tell you, in Mackinac Island, and you may be familiar with Mackinac Island, there's one business that wasn't able to open some aspects of their business because it's an employer that required 1,000 workers, and there's only 500 people that live in that town year-round. And, it's a highly summer vacation area, and so we're experiencing this, but how do we make that happen in terms of with the administration? I understand how Congress works, but with the administration, because there are some, I think, in the administration that may not feel that these visas are necessary.
So Congressman, as I said earlier, I am very sensitive to the needs of those businesses in that are highly seasonal, where the local workforce demand, and you gave a perfect example, is insufficient. And that is what I think the core of the visa is about. Last year, Congress gave authority to DHS in consultation with the Department of Labor to increase the cap. And then Secretary Kelly made the decision in consultation with me, and he and I are shoulder to shoulder in that decision, that the visas would increase by 15,000. What Congress did last year, and I just want to mention this, is they gave discretion to the administration. And as a result, we had to write a rule, and that takes time. And so the mechanism that was used last year, while we made the discretionary decision to increase the number by 15,000, by the time the rule was written and issued, that 15,000 was not able to be focused on businesses like you're talking about. Mm-hmm. And so I would urge Congress, as you're looking at a solution this year, and we're happy to our department and DHS, if I could speak for them, I think would be happy to work with your staff to the extent that you're looking for solutions to craft something that does not require rulemaking. Because if we engage in that rulemaking, we're going to be exactly where we were last year, mm-hmm. and that doesn't solve your problem, and that doesn't really address what we're looking for either.
Okay. Thank you very much. Thank you, Mr. Chairman.
Thank you. Just to advise the committee, we're going to continue. The Secretary has a hard stop at noon. We're going to stay at 5 minutes, but if you can do it under that, Ms. Clark will be very grateful. Mr. Molinar, if he hangs around, will be very grateful. I'm going to set the opening example. I just want to ask you one question. We've had always a persistent problem with the skills gap, and it's always difficult. You probably operate more training programs in your department than anybody else in the government, but it's a stubborn problem. It's a difficult one. So could you advise the committee on any special initiatives you're taking or looking at how we have traditionally done things so that we could hopefully cut into that a little bit more and put people in really good paying jobs that have a real future with it?
Mr. Chairman, thank you for the question, and certainly we've talked about the apprenticeship program that we're very excited about, and we're excited about expanding that even more than has been expanded in the past. Let me note something that's in the budget, that was in the budget last year, that I think is incredibly important, and that is flexibility for governors. The way monies are appropriated for governors currently, they have different programs that they administer, and governors on both sides of the aisle have come to us and said, we have this great idea that works in our state. Can we take money from funding source A and use it for funding source B? In-school youth versus out-of-school youth, for example. And I am highly restricted in my ability to allow governors to sort of move those funding streams around. And then governors have said, well, the compliance and accounting efforts behind those are so onerous that we're not able to use monies as efficiently. And so we've asked again for additional flexibilities so that we can work with the governors to recognize that Oklahoma may be different than California and that the needs of Oklahoma may be different and what programs work in Oklahoma may be different. And so I'd ask the committee to look at those flexibilities because I do think they're important.
Well, I appreciate that, and we will look at that. I think that's an excellent idea, and we want to try and work with you on that. With that, let me go to my good friend, the gentlelady from Connecticut.
Thank you very much, Mr. Chairman. Mr. Secretary, just a couple of things. My colleague, Mr. Harris, was clarifying the record. I would also like to make a point. This has to do with your commentary on job growth, which I would just say, the last year of the Obama administration, there were 196,000 jobs created per month. First year of the Trump administration is 171,000 per month. So in fact, job growth slowed. With regard to your selecting the 10th Circuit over the 9th Circuit, it would just seem to me that your view seems to view that there is legal wage theft is okay. I say that, but at the same time, we will take a very, very hard look at legislation which will undo that and promulgate a law here. Let me move to apprenticeships. Just a point, 2 points I want to make. You tout the benefits of apprenticeships, such as the average annual wage of $60,000. However, you failed to clarify that such benefits are only for registered apprenticeships. The appropriations language is clear that it can only be used for registered apprenticeship programs and not for this new scheme. I would comment on the subcommittee's progress report. If you can get back to me on this, I would be helpful. That one of their recommendations on this is the recommendations from President Trump's task force on apprenticeship expansion. It talks about risk-sharing opportunities. A recommendation is income-sharing agreements provide a new tool that could help businesses fund apprenticeship training costs. Investors-sponsored apprenticeships by investing in their training, and in return, they take an equity stake in the apprenticeship's wages over a certain period of time. That would appear to me, this is the same as indentured servitude. That you get that. So I would love to have clarification on that, and if you can do it for us in writing, that would be great, because I'd like to move to the International Labor Affairs ILAB. If you will. ILAB is one of the few federal agencies with the explicit responsibility to help level the playing field so that American workers are not forced into unfair competition. And we've seen since entering NAFTA that Carrier, GE, Nabisco have moved jobs across the border to pay poverty wages, dump toxins before selling the products back to the U.S. as imports. 2019, you proposed to cut 80% of funding for ILAB, explicitly seeking to eliminate the grants for labor capacity building. That would help countries like Mexico protect worker rights, fight child labor, improve wages and working conditions. Your testimony said when trading partners fall short of labor standards set forth in trade agreements, they can create an uneven playing field that hurts American workers. Given the loss of nearly 1 million jobs, large part due to the absence of healthy democratic institutions, independent workers' organizations in Mexico, how would you describe the current status of labor rights and working conditions on the ground in Mexico? What are you prepared to do about it? Do you believe it's fair for workers in my district and districts across this country to compete with workers in Mexico who are paid poverty wages and effectively have no freedom to join in a union of their choice or negotiate for better wages and working conditions? I have others questions, but I'll submit them for the record.
Fair enough. Ranking Member DeLauro, there are a number of assumptions and statements that I, let me just note that they're yours and that I would not necessarily agree with your characterizations of what I have said or otherwise, but let me move on and just address your question.
This was a quote from your testimony. I have a quote. What
I take no issue with,
Okay.
I was referring earlier to your summary of what I had said on other issues.
Gotcha.
And so we currently have a request that we investigate the labor conditions in Mexico. We are looking at that request within ILAB, and because that request is pending, I don't think it'd be appropriate for me to prejudge how that request will be treated. But it's something that we're certainly aware of. It's something that is part of the discussions in the NAFTA.
What about the 80% cut, though, in the ILAB grants that allow us to do these kinds of things?
So the budget as proposed looks to reduce or eliminate most of the grants out of ILAB. And this goes to I think, a question of policy that Congress is going to have to address. What my testimony made clear is that when other trading partners violate labor rights, it creates an unfair labor system and an uneven playing field, and that's absolutely right. The question is, should the American taxpayer be paying for those countries to address those issues, or should those countries themselves be paying for it? And so if you look at the budget and what the budget is doing, most of the reductions that you're referencing go into grants that are provided those foreign
Capacity building,
countries to
yes.
address that. And I think Congress needs to decide whether it wants to spend American taxpayer money here in the United States or in other countries.
You've answered my question, just one last comment, but we're okay with a tax code that says you can go to Mexico and only pay up to 13% on your profits. But if you stay in the U.S., you pay 21%. Wow. Okay, thank you very, very much, Mr. Secretary. Thank you, Mr. Chairman, again.
Absolutely. With that, we'll go to my good friend from Maryland, Mr. Harris.
Thank you very much. And look, I'm kind of glad we passed tax reform. We had a rate of 35% before, and we're going to repatriate money, and we're going to bring jobs back in America. And I just saw statistics that we increased manufacturing jobs by 1 million last year, which is pretty phenomenal.
Have a bridge
That's what we're missing. Anyway, let me just, and I have two specific questions, but just to close the loop on the H-2B. So if Congress is going to solve it in the omnibus bill, because that's really the only vehicle we're going to have that's going to do anything before the summer season, in my case for crab pickers or the gentleman from Michigan from Mackinac Island, it's your testimony that we have to be careful that we write something that doesn't require a department to write a rule. Is that right? Because then it would be a Pyrrhic victory. We could put the cap at whatever we want. None of it would be available by summer.
That is correct, Congress.
Okay, so we'll work on that. Okay, my two specific questions. One is that, and we talked about the overtime regulation already, but you've reportedly said that you're considering including an automatic increase mechanism in the proposed overtime regulation the department's developing, but the Fair Labor Standards Act doesn't, by my impression, doesn't include language permitting that, and indeed it says that the overtime exemptions shall be adjusted through regulations. So are you going to need a statutory change in order to put a automatic increase mechanism into the regulation?
Congressman, we issued a request for information. We received several comments. Some of the comments raised that issue. That's an issue that we are going to look at. We are not asking for any statutory change at this time. We will examine whether the statute allows for an inflation adjustment and whether there are mechanisms that are really in keeping with good policy within the statute.
Okay, no, thank you. And again, if if you need help, we can hopefully we can provide that help on the statutory side. Now, the last 3 minutes I'm going to take is going to be a topic that I was unaware of until I saw a letter back in January from the Chairman of Education and Workforce to your office about what are called these worker centers. Because in my understanding is that the Labor Management Reporting and Disclosure Act, I think kind of just makes it fair to someone who's going to be come under a union to make sure that the union is doing things right, that it's not, the corruption's not occurring, financial responsibility, the whole thing. And that now what have come up are these things called these worker centers that apparently are affiliated with unions, sometimes closely affiliated with unions, but in my understanding, they may not have this reporting requirement. So I don't know whether this is a overt effort to just avoid reporting requirements, or what's going on. Can you just fill me in on what in the world is going on with worker centers, and are they truly able to skirt the law under the Labor Management Reporting and Disclosure Act? And will the Office of Labor Management Standards, I don't think you have a new director in the office yet approved. Are we paralyzed by this, and these worker centers just going to spring up all over the place?
Congressman, first, I hope to have a new director in place soon. We're not paralyzed by this. To the extent that worker centers are acting as labor organizations, and to the extent they're covered by the LMRDA, then they should in fact be covered by the LMRDA, and I've already asked OLMS to look at this and to determine whether any worker centers are acting as labor organizations, and if so, whether they in fact should be filing. So this is something that's already been addressed and is ongoing.
Now, if you find that they are in fact acting as they fall under the Disclosure Act, what can you do? I mean, what mechanisms do you have for enforcement of that act for these worker centers?
Well, Congressman, if they fall under the act, then all the enforcement mechanisms of the act would apply, and so they would have to follow the disclosure requirements of the act, or there would be enforcement. And if there's something that I hope has been heard multiple times by the committee, it's that we were going to follow the law. And that includes both OSHA, and that includes wage and hour, and that also includes the LMRDA.
So are you still trying to determine if some of these fall under, or is your belief that they do fall under it, and you're just initiating these the necessary actions under the act?
There have been allegations that some worker centers are functioning as labor organizations, and so I have directed OLMS to consider those allegations and to determine if they in fact are true. And if they are true, and if in fact they fall under the LMRDA, then the LMRDA would apply and they would have to disclose. And they would be subject to the provisions of the LMRDA.
Thank you very much. I yield back, Mr. Chairman.
Thank you. We'll next go to my friend Ms. Lee from California.
Okay, thank you. Let me ask you, Mr. Secretary, a couple of questions with regard to the administration's proposed cut to the Supplemental Nutrition Assistance Program, SNAP. I believe it's about $213 billion, 30% over 10 years. It also, though, radically really restructures how the benefits are delivered, like through Harvest Box, that includes eligibility cuts and workforce requirements that would cause, and I believe it's about 4 million people to lose SNAP benefits altogether. That's according to the Center for Budget and Policy Priorities. Now, the cuts, though, in your workforce training programs disturb many of us. They're problematic because these programs are supposed to help people get jobs. So, of course, you're talking about the 24% cut for job training, 34% cut for dislocated worker, National Reserve, again, the reintegration of ex-offender, 11% cut, 13% cut, Office of Federal Contract Compliance, 29% cut, Office of Disability Employment Policy, 79% cut for International Labor Affairs, 72% cut for the Women's Bureau. Now, let me ask you, how do you expect people on SNAP to get a job if you're cutting the very programs that they are supposed to help? Secondly, I hope you all are aware of the fact that the majority of people who receive SNAP benefits are already working, and that 2/3 of individuals who receive SNAP are children, seniors, and the disabled. And so what do you think about these cuts that undermine, first of all, the ability to work, but secondly, these onerous work requirements now that are going to cause millions of people to lose their SNAP benefits? And then the second part of my question has to do with just an increase in the minimum wage from $7.25 an hour. It's been stagnant. I believe the federal tip minimum wage has been stuck at about $2.13 an hour for about 25 years. And I do associate myself with the remarks of all my colleagues on the tip wage issue. But I remember at your hearing, you said that whether it's those who are working, those who still seek work, those who are discouraged or underemployed, or those who have retired, if confirmed as Secretary of Labor, I will advocate for them. That was your quote at your hearing. And so do you support legislation to increase the minimum wage and also eliminate, of course, the tip wage, which we discussed earlier?
So, Congresswoman, thank you for the question. And I'm, as I was listening to your percentages, I'm trying to match them up with my information on the budget here, and they don't align. And I'm trying to understand why. It may be that there really are two different budget proposals that we're working with here, because after Congress reached the resolution that it did, additional monies were put in the budget. And so as I'm looking through this budget, on the programmatic side, putting aside the decreases, let's not even go on the programmatic side. The overall decrease is 10%. No one agency within the department is receiving other than ILAP is receiving other than ETA is receiving substantial reductions, And the reductions within ETA, which is the agency that does much of the workforce training, focus on particular programs that are being reallocated. And so those are the migrant and seasonal farm worker and the community service for older Americans. And certainly the hope is that with increased flexibilities, those can be made part of the larger program. So I don't know where the percentages are coming from. You have those, I have different figures. Let's put those aside. I strongly believe that workforce education is important and critical. And in terms of returns on investment, one of the best things that we can do is provide skills so that someone can get a job. Going to your point of reentry, one of the things I've said, and I've been saying this, did my mic go off for some? And I've been saying this since I was United States Attorney. I'm a big fan of reentry programs. I was a prosecutor, and so I say this from the perspective of a prosecutor. Once someone has served their time, the best thing we can do for them is get them a job.
Sure, Mr. Secretary, but again, we'll have to reconcile these figures, but I see a $10 million cut in the reintegration of ex-offenders in this year's budget. What about the minimum wage?
I would ask the lady-
$7, pardon?
Our time's expired.
The minimum
So
wage
I want to be able
question
to
is-
give Ms. Clark.
Oh, I'm sorry. Excuse me, we'll follow up with you.
Thank you very much. I appreciate that. Ms. Clark, if you will indulge us, Mr. Secretary, we're going to go just a few minutes over so my friend can get her second round in.
Thank you very much, Mr. Chairman and Mr. Secretary. We're on a roll of working together. We're going to work together on tip wages, and I hope that we can work together also. I want to go back to some of the comments my colleague from California had around mandated arbitration, because it was the rule under the Fair Pay and Safe Workplace Executive Order that was mandatory arbitration for a host of civil rights, including sexual harassment and assault, was banned for federal contractors who have a contract for a minimum of $1 million, so $1 million or more, extensive taxpayer funds. Would you be open to working in reinstating that ban as we are in the Me Too movement and understand the impact that sexual harassment and assault has in our workplace, and that when you are receiving taxpayer dollars as a significant federal contractor, there really is no place for this mandated arbitration around sexual harassment claims that keep them quiet and out of the courts. And I think I understood you to say this had been a private contracting, and that's not what I'm talking. I'm talking about federal contractors who, until this administration rescinded those protections, had to do away with the mandated arbitration around Title VII claims.
And so Congressman, I'm certainly open to discussions, and what I was trying to point out is that there are really two parts to this. One is whether or not there should contractual arbitration should be permitted or not, and that's a policy question. And the other one is, if it is permitted, what might appropriate safeguards or caveats be around that arbitration process? And before we eliminate, and in something that's been in federal policy for decades, let's talk about maybe there are safeguards that would make sense. But I think the key part is let's talk about that, and let's discuss, and I'm certainly open to that discussion.
Okay. And the last one I wanted to mention was, as Massachusetts and the country continues to fight an opiate crisis, 1,900 lives lost in Massachusetts alone last year to overdoses. I think there is a real role for the Department of Labor in working with us on job training programs for those coming out of treatment. Would you be open to that? Have you been asked by the White House to weigh in on the opiate crisis, and what tools you have and resources for people?
So, Congresswoman, I agree entirely. If you look at the data, I believe the Bureau of Labor Statistics, in one of the surveys, I forget exactly which one, asked, did you take a painkiller yesterday? And I believe the response, 44% of prime-age males outside the workforce answered yes. I believe professor, I'm blanking on the name now. He's in Princeton, and he was President Obama's, one of President Obama's economic advisors. I think was it Kluger? Yes, Professor Kluger. Did a separate survey and found 47%. His survey went on to say, was it a prescription drug? And it was either 31 or 33% said yes. Not last week or last month, but yesterday. And so this is, a major, major issue. And Professor Kluger concluded that I believe 20 to 25%, according to him, of prime age males, which was his focus, that are not working because of opioid addiction. And so I've already asked ETA within the Department of Labor to see within existing funding what we can do to address this, because I think whether it's 20% or 15 or 25, we can have a long discussion about, but that is a very high number irrespective. And so to the extent that I have flexibility within the ETA budget, I have already asked ETA to see what we can do to target programs specifically for individuals that have opioid addiction so they can come back and get a job. And if I could briefly, going back to the reentry issue, I think there is an analogy to be drawn here. Just like the best thing you can do for someone coming out of prison is work to give them the skills to get a job. I think one of the best things you can do to address an opioid addiction is give someone a job, because with the job comes a confidence and a sense of belonging and all these other soft benefits that are associated with employment that I think do help combat opioid addiction, and so gladly.
Wonderful. And I would agree with you that the two issues are intertwined and that it is a great use of your budget and asking for additional funds for your budget around this, because the money we will save in the long run by having people gainfully employed is well documented. Thank you, Mr. Chairman, very much.
Thank you, Mr. Secretary. Thank you very much for your time and for your indulgence here at the end. We appreciate that. I want to thank the members of the committee as well for a very robust exchange. It was a good hearing. With that, we're adjourned.
Thank you, Tom.
Thank you.
That's okay.